A deed is a written document that has two purposes. One, to transfer ownership of real estate, and two, when properly recorded, to tell the world who currently owns a parcel of real estate. To understand how a deed works, we have to understand the parts or elements of a deed. As a real estate agent, you'll occasionally have to review deeds as part of your research for clients. To be an effective advocate for your client, you have to know what information is in the deed, what each part means, and how that information is useful for your transaction. While there are many types of deeds, like warranty deeds and quitclaim deeds, nearly all have the same elements. Certain details vary from state to state, but elements we'll talk about today can be found in just about every state. Where there are notable exceptions, we'll let you know. Note first the title of the deed. Is it a warranty deed, a quitclaim deed, a life estate? This will be a flag whether more detailed research, like a title search or survey, is needed before the transaction goes forward. If it's only a quitclaim deed, the seller or grantor did not provide many warranties or protections for the buyer, or guarantee. You may want to do a survey or a more extensive title and tax search. The title is not necessarily a legal required element, but is important to understand what sort of paper you're holding. The first legally required element is that the deed be in writing. This sounds obvious, but people rely on oral contracts every day. The law in all 50 states, as handed down from our English legal ancestors, is that real estate can only be conveyed in writing. This is to protect against fraud and people stealing land. In fact, the ancient law where this rule was created is called the Statute of Fraud. There are rare exceptions, like adverse possession, but even that eventually requires a court order for recognition as a valid transfer. For all practical purposes, a deed must be in writing. The grantor, the person conveying the title to the property, must have legal capacity to be the grantor. This means they own the interest in the property that they are conveying. If the grantor doesn't own the interests he's conveying, then there hasn't been a transfer of title. The deed is meaningless. It would be as if you wrote a deed to yourself for the Brooklyn Bridge. You don't own the Brooklyn Bridge, so you can't give it to anyone. Capacity also refers to the ability of a person to represent a corporate entity or other non-human grantor. Corporations, partnerships, trusts, and all manner of entities can own real estate. The person signing on behalf of the entity must have the legal capacity or power to sign. A trust can be represented by a trustee, a partnership by a designated partner, a corporation by an officer authorized by the board of directors or bylaws. The deed must also be conveyed, meaning handed over to the guarantee, the person receiving title to the property. If you write a deed and keep it in your file cabinet, you haven't transferred title to the property. It has to get into the guarantee's hands. Practically, at most closings, the seller will sign the deed and give it to the closing attorney or title company. Then the attorney will have the deed recorded with the proper government authority. And finally, the attorney will send the original recorded deed to the buyer a few weeks later. These are parts of a deed that won't necessarily appear on the face of the document. So what are we looking at when we see a deed? First, the deed will have a date. The date tells you when the property was conveyed. This isn't just a nice frame of reference. it is important for the order of the title history. If deeds are dated out of order, there will be a question about who really owns the property. If Kim sells one of her houses to Chloe, and the deed is dated May 10, 2017, and Chloe sells the same house to Bruce, but the deed is dated May 9, 2017, Bruce doesn't own the property in the end. Why? Because on May 9th, Chloe didn't own the house yet. Even if the transaction were done in the correct order in real life, the title owner of the property is still Chloe and not Bruce, because of the dates on the deeds. Next, the deed lists the parties to the deed, the grantor and the grantee. The grantor is the person or entity selling or giving the property. This is the prior owner. The grantee is the person or entity buying or taking the property. This is the current owner. When looking at the grantor and grantee, it is important to note the capacity in which they're buying or selling. In the case where the grantor is an entity, the signor will have next to their name something like the duly authorized representative of the corporation, or in his capacity as president of the corporation. If the person signing doesn't have a legal capacity, or the grantor doesn't have the legal capacity to convey the property, then there is a problem with your deed. In that case, consult with an attorney about your options for helping the transaction go forward. In order for a contract to be valid, there has to be consideration. In other words, the exchange of something of value. For the conveyance of title to property from the grantor to the grantee to be complete, the grantee has to give the grantor something of value. The deed must state that something of value was given by the grantee to the grantor in exchange for the title to the property. The consideration clause takes a few different forms depending on your state. In some states, consideration has to be nominal, meaning something symbolic. In those states, the deed will state the following words: in consideration of $10 paid in hand. Now, was a piece of real estate sold for $10? No, of course not. It's just a legal convention to make a valid contract and show that the property was given for something of value. The actual sale price of the property will be listed on another form or a tax filing. In other states like Tennessee, the actual sale price has to be included on the deed itself. In transactions between family members where property is given as a gift, some states allow the deed to state something like, in consideration of a lifetime of love and affection. The deed must state that the property is being transferred. This is called the granting clause. It will have wording something like, the grantor does hereby convey, transfer, sell, alienates the subject party to grantee. These are the legal words that reflect the grantor conveys his entire interest in the property to the grantee. The specific interest in the property being conveyed is called the habendum clause. The deed will state the type of interest being conveyed to the grantee. Usually, this will state a fee simple interest, meaning all possible ownership rights. But there are other types of interest, like a leasehold or life estate. Practically, most conveyances are fee simple. What property is being conveyed by the deed? You'll find this in the legal description. All deeds must contain a description of the property being conveyed. Legal descriptions can be included in the deed itself, or an Exhibit A attached to and recorded with the deed. The description can be simple, referred to a deed book and a page number of a plat recorded with the county real estate records. Or it can be more complete, listing the metes and bounds of the property. This is a technical description of the borders of the property. The description will begin at a point, usually created by the county, and then extend for a distance and turning at angles to eventually complete a border. Most residential real estate has well-established metes and bounds. Commercial property, or raw land, may have a more complex description. The last element of every deed is the notarized signature of the grantor. If the grantor is a corporation or other entity, an authorized representative with authority and capacity will sign with their authority indicated by their signature. The signature must be witnessed by a notary public, who will sign next to the grantor's signature and affix their seal or stamp. This is to show that a person authorized by the state to administer oaths has verified through identification that the person signing is, in fact, the grantor listed on the deed. Some states require 1 or 2 non-notary witnesses to the signature, in addition to the notary signature. The notary block on the deed varies by state. Some are quite large, like California. Others are shorter, like Georgia. But they all essentially say the same thing, that I, the notary, have verified the identification of the person signing, and it is the right person. Once the deed has been written with all of its elements and signed, it must be given to the grantee. As we discussed earlier, in modern real estate closings, the closing attorney or title agent takes the signed deed and brings or mails it to the county real estate clerk for recording. Recording means that the deed is scanned or copied into the official books of the county for everyone to see. A stamp is placed on the deed with the deed book and page number. In earlier times, the county maintained a physical book of copies of deeds, so the deed book is the book number. The page is the page in the book. Older records are still kept in the books, but many counties have switched over to an electronic system that can be searched by computer. The deed book and page is a reference for the deed. It can be referred to in other deeds or legal documents, and will forever be the point of reference for that specific transaction. Recording the deed is generally considered evidence of delivery by the grantor and acceptance by the grantee. This completes the process of transferring title to the new owner.